usually we see the opposite. We see that the witnesses in the car are on our side if we're gonna call them, and not basically state witnesses that incriminate our clients. Hi, Attorney Scott Simmons here, partner at the Rossen Law Firm, criminal defense and DUI attorney, here to talk to you about an amazing win where we saved our client's future. Our client was charged with DUI enhanced while she was in nursing school. If she were to resolve her case to a DUI or be found guilty of DUI, it was going to ruin her career that had just started. She had an attorney before she hired us. They weren't working out. They weren't willing to do the work that needed to be done on the case. She came, she met with us. She did a strategy session with our firm. We reviewed the case, what little we could at that time. We saw a defense strategy that we could implement going forward, and they ultimately decided to retain us, her and her parents. We then started taking depositions on the case. We reviewed all the body-worn camera on the case, and then we filed a motion to suppress. While we were doing that simultaneously, we also had the client work up mitigation. So mitigation is when we have clients, they have family members write letters, other people that know them in the community. In this case, she basically had, from when she started nursing school, all the letters of recommendations, all of her transcripts. We added all of that together, and that coupled with the legal arguments we made, we gave that to the prosecutors. We gave that to the state attorney's office. They were able to review everything and just see that this girl wasn't just this one act, but it was so much more. We also were able to talk about the act of driving under the influence and why this was an exceptional case. So this is a case where Caitlin was driving, but she was kind of forced to drive. She was forced to drive by her at the time boyfriend, now ex-boyfriend, thankfully, who kind of said, I have an important future. I'm trying to become a firefighter. I'm not gonna drive. You're gonna drive us. And then she got pulled over by the police. He spoke to the police. He completely threw her under the bus, said, yeah, she's been drinking. I told her we shouldn't drive. I told her. But he's sitting there in the passenger seat. He didn't call her an Uber. He didn't take the car keys from her. He forced her to drive, and he wanted her future to be ruined instead of his. Ultimately, that didn't happen though, because she retained our law firm. We filed the appropriate motions, and then on the day of that motion to suppress, her case resolved not to a DUI, but to a change of charge to reckless driving with a withhold of adjudication. And what that withhold of adjudication means is that she was able to seal this case off of her record after she finished the probation. So at the end of the year, it's going to be like this case never even existed on her criminal record. She's going to be able to start applying to hospitals and continue her nursing career. And it's a great result for a great client. I would say it's rare that we see cases where our clients' friends throw them under the bus entirely. So this case was, again, he's sitting in the passenger seat. She's like, yeah, she drank. Usually the passengers are quiet or they're not incriminating our clients. A lot of times our passengers are defense witnesses. So when talking to our clients, we say, hey, is there anyone who you think could talk about how you weren't impaired? Because again, in these DUI cases, you're asking an officer to make a decision based off about 20 minutes. The average DUI investigation is about 20 minutes long, from the stop to the exercises to taking them to the BAT facility. So they have about 20 minutes of knowing this person to decide, hey, does this person have an accent? Do they walk funny? Are they just weird? Some people are just off. And if you met them for the first time, you have that feeling, they're off. Well, the officer thinks it's DUI, but your friends and families, they know, well, that's just who they are. That's just Caitlin. So you're able to have those defense witnesses come in and testify and say, no, I was at the party with them, or I was at the bar with them. I saw they only had 2 drinks. I know I bought both of the drinks when we left, walked out of the bar totally fine. I got in the car. If I thought there was an issue, I would have drove. I wasn't intoxicated, or I would have called us an Uber. I have the Uber app. No, I thought everything was totally fine. So usually we see the opposite. We see that the witnesses in the car are on our side if we're going to call them, and not basically state witnesses that incriminate our clients. The way we have to help nurses, same with anyone else with a professional degree, is you have to know what the consequences are. I just did a consultation with someone, a commercial driver's license, for example. There's lots of different jobs, commercial driver's license, so CDL holders, truck drivers, nurses, doctors, lawyers, people that have a board of nursing, a board of college that they have to report to. It's very important to know what, if anything, could disqualify you from keeping your degrees. And know what fights you have to take. So for commercial driver's license, for example, maybe you can't even take a reckless driving, but 9 out of 10 of our clients want a reckless driving. Well, if you hire an attorney who doesn't know the difference between the two, you thought you just got a great result until you get a letter in the mail saying, hey, your commercial driver's license was just suspended or revoked. And you now thought you had a great result and it ruined your life. So it's very important to know and to keep updated with the law because it changes as to what can a client resolve their case to and what can't they resolve their case to. For a lot of clients, a withhold on a reckless driving is a huge win. There's no conviction, there's no jail time, there's no extra driver's license suspension typically, no FR 44 insurance. Those are the big 4 things most of our clients want. But when your livelihood is on the line, sometimes it's not enough and we have to get a different result or we have to go to trial and that's the only result we can get. One is you have to know if an attorney is not doing a good job for you requires you to have an open and honest conversation with that lawyer. You should have an idea of what's going on in your case. And what that means is, do they have the discovery yet? Have they talked to you about the discovery? Have they told you what the game plan is? Have you talked about possible resolutions and the timeline on those resolutions? Have they explained to you at all who your judge is? These are just questions that, and again, everybody is different. So the amount of information you want to know may be different than the amount of information your friend wants to know. I have some clients who say, Scott, do everything. You tell me when I need to know information. And if that's how they want to be represented, that's totally fine. Then I have other clients, Scott, anytime anything comes in on my case, I need to know exactly what it is. I want a copy sent to me, and then I want to have a discussion with you. And a lot of people are usually in the middle of those two. But you have to have an attorney that's willing to communicate the way you want to be communicated with and give you updates the way that you want updates. Because if you're not understanding the process, then you shouldn't be happy with the process because you have to at least understand what's happening. Because no matter what, every case ends with you having to make a decision on what you're going to do. And the only way you can make a knowing and voluntary intelligent decision is to know what's going on. So you have to have an attorney that knows, that is telling you what is going on. Again, you have to know what the possible resolutions you're going to take is. For a nurse, one, does she already have a job at a hospital? Is she a mandatory reporter? So a lot of our clients that are nurses, if you're arrested within 24 hours, you have to report that arrest. Failure to do so is supposed to lead to you being dismissed from your job. Even if we beat the DUI with nursing, you still have to answer to the board. So we have clients who we beat their DUIs, but they still have to answer to the board and they need letters from us to explain what happened in that case to make sure that the punishment with the board is appropriate. So sometimes it'll just be, hey, you need to go and do this extra drug and alcohol evaluation, follow-up treatment, and you're good to go. Other times it's, hey, even though you beat the DUI, sorry, we read the facts, too egregious, we're offering you another suspension. So you need to know the differences that are going to occur, and you need to have a conversation with your lawyer. Even if they're not going to represent you at that hearing, at least have a conversation to understand what's going on to see if you want to seek other counsel for that part of the case. We're the best attorneys because we understand the processes that need to go and we have relationships to help guide you to other referrals who may be able to help you if you want to hire an attorney to represent you with the board. Even though that's not something we do, it's something you may want to look into. Again, this is your career. You may want to spend that extra money, make sure that you're protected in that additional way. And we have those connections. We can help introduce you to those people and we fight our cases. So we're not just going to, especially if you have a nursing license, we're not just going to resolve your case to a DUI as charged at your first, second court date. We're going to go through all the discovery. We're going to go through it with you. We're going to do that mitigation package and we're going to put forward the best fight that we possibly can to get you the best possible resolution that we can for your future. Yeah, if you're a nurse and you got arrested for a DUI or you have a pending DUI case and you want us to talk to you about your case, please give us a call at the Rossen Law Firm, 754-206-6200. We'd be happy to help you out.